All right.
Hey, that looks great.
All right. So Belinda and I are going to be doing this presentation this evening. Mike and Addie, please feel free to chime in. For those of you that don't know or have not spoken, Addie is one of our wonderful frontline attorneys who has agreed to join us this evening. So excited to have her on. She fields a lot of our calls for us. I believe most of her calls are business, but she does take a lot of other calls as well. So thank you, Addie, and welcome. All right. Belinda Lasan is our supervising attorney, and she is on this call this evening as well. And she has been with the firm for a very long time. She oversees all of our frontline attorneys, and we work together in overseeing the LegalShield department. And she's a wonderful person to be working with. I'm so blessed to have her. Okay, in this particular presentation tonight, we're going to talk about the B1 benefits, the basic benefits that members get. So who can receive assistance under this consultation service? We're going to talk about types of consultation services under B1 consultations, telephone consultations, letters, or telephone calls, and doc reviews. Exclusions. This is important because I think a lot of times members don't understand what is excluded from their benefits, and that's a hard pill to swallow when you have to tell someone no. We're going to review various scenarios involving the consultation services. Okay, so who can receive?
And I just want to just jump in and say B1 is connected to the old plan, right? That's a reference to like Section B or something in the old plan. We used to call it T1, right? Title
Yes.
1. You know,
Then
for
it's
those who've been
benefit
around.
one.
Yeah, benefit
and
one.
Now we try to call them the consultation services because
Right.
that's what they're labeled under the plans now. So
that's right. They got rid of all of the numbers in the plan, and all of the lawyers were very angry about that because we didn't have anything to refer to anymore, you know? But I'm really glad that you all, the associates, are joining us for this. You know, you're really key to our success, because the more you understand the plan, the better you can prepare your customers for what they will experience whenever they call us and use the plan. And that is just a real key to success, a real key to a happy member. So we really work together in that regard. You prepare them well, we over deliver, and you're going to have a member that's going to be on board for a long, long time. And we just appreciate the work that the network does in getting folks prepared and understanding what they're buying and the benefits they're going to receive. So I just wanted to note our thanks in that regard, and how important your role is in this.
So let's move on. Who can receive assistance under the consultation services? Go ahead, Belinda.
A covered person under our plan includes the member and their spouse, unmarried children of the member or their spouse who are under the age of 26, who are either members of the residents of the member's household or full-time students. Children under 18 for whom the member or member's spouse is the legal guardian. And dependent children, no matter what age, who are physically disabled or mentally incapacitated. And note that a dependent is the natural or adopted child of the member or the member's spouse.
Go ahead, Belinda.
For the telephone consultation. Under the telephone consultation services, the covered person may receive toll-free telephone consultations on an unlimited number of personal legal matters. This is a change from the older plans that were referenced as the Access family plans, plans that were sold, I believe, pre-2011. Under those plans, there were a limited amount of business consultations that the members could receive. Under the new family plans, they only cover personal legal matters unless you purchase a business supplement or a separate small business plan. They also receive consultations on each legal matter are available to the extent the provider attorney deems it necessary to adequately advise the covered person on the legal matters. So the attorneys will speak with the member multiple times at times about their legal issue as they work through the problem. However, there ultimately does come a time where we are at the limit of the consultation benefits, and then other options will be presented to the member at that time. And then at the provider attorney's discretion, up to 1 hour of legal research concerning the legal matter. And this is generally provided in unique situations that, you know, oftentimes we might get a call from a member who presents us with a unique legal question or something that the attorney may not have encountered, you know, so sometimes they'll also ask other attorneys in the firm if they've encountered that situation, and if not, they will spend an hour researching the legal issue.
Expectations to the telephone consultation service. The consultation service do not include business-related matters. This includes any matter involving ownership, management, or association with a business, partnership, corporate entity, or trust. Any income-producing property or venture, example, where the member is a landlord. This is when they're required to get the supplemental business benefits, a small business plan, in addition to the services that they have. Belinda, do you want to, or Addie, do you want to say anything else about this particular
Sure, Noemi.
section?
I'll jump in for a minute here. One item that I'd like to mention about this is a lot of times members are confused. They do think they have business related benefits under their family plan, and they do not. And I always take the time to go through and explain their benefits to them. But I think it would be helpful if they knew up front more that business matters aren't covered, because I do deal with a lot of landlords, and they often, you know, say, oh, I didn't know I needed to get the supplement. They generally always do, and they're very grateful, and I can help them out. But it's just something that they don't know. And then on the flip side, sometimes business members also want personal matters taken care of, and we have to explain to them that actually they need to have a personal membership as well.
Yeah, and we don't completely shut them down. We generally will provide them with a courtesy consult when the attorney speaks to them. We won't go so far as to review documents or do letters or do anything else that's provided under the consultation. But we don't just say, I can't help you, sorry, you don't have the right plan. You know, we'll talk to them about their legal issue and then encourage them to get the appropriate plan so we can assist them further.
Right. This is a great upsell opportunity. And I wish that we knew who the selling associate was, that we could send them directly back to you all for that upsell opportunity. We don't have that information available to us, but we do encourage them to contact the home office and talk to somebody there about upgrading or adding a business plan to the membership.
Assist with pro se representation or the completion of litigation documents.
This is a big one. We get a lot of calls where someone has been served with a lawsuit, usually at the magistrate's, and they want us to call the court or write a letter to the judge or help them file their answer, you know, or they may be in the midst of litigation that they've been handling on their own, and all of a sudden they've been served with legal papers that require some sort of responsive pleading, and they ask us to assist. We are not permitted to assist with pro se representation in the Commonwealth of Pennsylvania. That's a violation of our ethics laws. And, you know, we certainly do not want to get tied up in a situation where litigation is representation is presumed by the court, and without us having entered an appearance. You know, we do have materials when someone is served in, you know, the magistrate court that our office has prepared, which basically just gives some general information on small claims in Pennsylvania, but we do not complete paperwork for people. It's just not something we can do. Generally, what our attorneys will do is explain how the process is, because there is a difference between arbitration and small claims and family court and workers' compensation courts. You know, they're all different types of courts. They all have different types of rules. So our attorneys will give them a general consult and then encourage them to consider a referral for representation for assistance, because we generally do not encourage people to try to represent themselves in court.
And
I was just going to make a quick comment. This is where there's a thing called unbundled legal services that is something that might be growing in the marketplace out there. But currently, you know, in some states are different than others, but Pennsylvania is a little bit behind the 8 ball, behind the times on it. Whenever a lawyer gets involved in a case, they're considered to be basically in for the whole case, right? That's bundled legal services, right? If you're on, then you're in it for everything. Unbundled, the concept of unbundled legal services would allow an attorney to help somebody with a very narrow aspect of the case. So we could get involved just for the purpose of helping them prepare that responsive pleading. That's unbundled legal services, but nothing else, right? That's not something that Pennsylvania really is good at recognizing. And so that's why this exclusion is in the plan. It may be that one of these days that concept changes, especially as the access to justice problem gets bigger, and it's already very, very big, that would allow more unbundled services and courts to recognize that. And I hope that that does happen. But for now, unfortunately, because of that bundled concept, we can't get involved in bits and pieces in a piece of litigation.
Thanks for that, Mike. Another area where their benefits are not covered is any disputes involving a provider or attorney or another provider firm or LegalShield itself. We do get calls sometimes from members wanting to open up an intake because they were dissatisfied maybe with what LegalShield took out of their checking account. Those types of matters we are not permitted to assist them with. So it's important for them to know that we can help them in those areas as well.
Or claims against you all, right? That's not covered. Your LegalShield.
Right.
Any matters which a provider attorney deems is resolved or has been raised unreasonable number of times without substantial changes of the circumstance.
And that's what I just previously discussed. At some point, you know, when there's been a letter, phone call, multiple consults, and the attorney feels that they're at the limit of what they can do under the consultation services, they will explain to the member that for the purposes of this matter, the consultation services aspect of their benefits has been exhausted. We do send letters to the members when that happens and explain to them that they'll be receiving that letter. If it is a matter that the attorney feels can be referred, we will certainly offer the referral under the preferred member discount.
And that's something that none of us really ever want to have to do, but sometimes we just get to a point where within the scope of our services that we can provide to members, there's nothing else that we can actually do. And I'm often sad when I have to tell a member that unfortunately there's nothing else I can do, but I can't offer them a referral. But sometimes we do get to that point.
Matters against the primary member's employer where the member purchased the plan through. So if you have your membership through your employer and you call in on an issue against your employer, unfortunately, we cannot open up an intake for that matter.
And we do have members who sometimes are confused about that, and the attorneys do take the time to explain that, you know, if it gets through to them. Normally it's caught on the front end by Noemi and Deborah Serrani, our administrators. A lot of times the members don't understand that if it's a matter that involves unemployment, they think that the issue is with the unemployment administration, but it's actually with the employer because the employer is the defendant in the unemployment filing. So, you know, we'll have situations like that arise. We do absolutely do our best to explain to them. You do have an amendment on your plan that does prohibit assistance with any matters that would be versus your employer.
Any matters where a dependent calls in against the primary member. Examples. Go ahead, Belinda, you want to do some
This would be an
examples?
example of this would be divorce, is the first one that comes to mind for me. If the membership is in the wife's name and the husband is listed as a dependent and he calls in on her, that intake will not make it to an attorney in our firm. It is not something that is covered.
Yeah, it's not a conflict. There's no benefits for that. So
Correct.
they're not in that husband will not be sent to an outside lawyer for consultation on the divorce. There's just no benefits for it. Right.
Right. And if it is a situation where there's a conflict, and that's usually a member versus member with two separate plans. So if we have two next door neighbors who were sold memberships and they have a dispute over a fence that one of them put up, and member one calls in and we will service member one, and then member two calls in the next day about the same issue, that member will still get their benefits. They just won't get the benefits through our office. We do what's called a conflict referral, where we will refer them to another attorney outside of our office to keep that wall, so that member gets the advice and representation and guidance that they need.
Letters or telephone calls. Under this section of consultation service, the covered person may, go ahead, Belinda.
Receive one letter or telephone call for their legal matter if the provider attorney in his or her professional judgment determines that a letter or telephone call would be of assistance in the legal matter. I will say here that we oftentimes stretch this a bit for the members, especially if we feel that we can help them with a second letter. It is not something that, will always be offered, but we do encourage our attorneys, if they think a second letter will help at no charge, we do oftentimes do that as a courtesy. Other times we have members who are demanding letters that are just not appropriate or we cannot do based upon the law, or, it's, for example, a letter to the Social Security Administration is not going to be read by the Social Security Administration, because the first thing they're going to do is send us a form to fill out saying that we represent the member. So there are certain places that we just cannot do letters to, like federal agencies that require letters of representation first, but where we can do a letter or phone call, we do. I can say I've done a letter demanding $5 for a member, so we do letters if one can be done. We do follow-ups if we feel they're appropriate, but at some point we will advise the member that any additional letters, if they're appropriate, we will be making a charge, and we usually charge at our hourly rate.
Go ahead, Belinda.
Any additional phone calls or letters from the provider attorney after the first one are provided under the 25% discount.
Expectations to the letter or telephone call service. A letter or telephone call is not provided in circumstances where the provider attorney in his or her professional judgment determines that a letter cannot be done in this instance. You want to touch base on that, Addie?
Sure. This is a relatively rare exception when dealing with letters. Oftentimes there's no issue, but sometimes we have a situation where maybe there is no actual legal merit, or they want a letter to go to, like Belinda said, a federal agency or somewhere where we know the letter will not be read, or we actually have an ethical issue if perhaps the member wants us to actually send the letter to the court or negotiate on their behalf. So there are occasions where we do have to say no, but I know I generally walk through with the member why there's an issue and why I specifically cannot send a letter, but if they want to send a letter on their own, I'll generally walk them through what they would need to do in order to do that.
Thanks for that, Addie.
You're welcome.
Again, as Belinda and Addie have stated, we cannot write a letter that involves communication to a judge or a court. That we just unfortunately cannot do that. Sometimes that's a hard pill to swallow for our members, but that's just something we cannot ethically do. a letter of appeal to a court or administrative matter. Again, these are things, anything associated with communicating with courts, judges, administration offices, we just simply cannot do.
Yeah, and this would include matters like with insurance companies. Oftentimes, insurance companies, through the appeal process of appealing a denial of benefits or something of that nature, we will read the language of the denial. They usually are sent forms and paperwork regarding that. And if the letter of appeal has to be done by a representative, that is considered an administrative matter that we could not do. There are some places, some insurance carriers that we could do a letter to. It just really depends on the circumstances. And we really have to take the time and explain that to the members when they call as to why this type of denial requires a referral, whereas another type of denial by an insurance carrier is something that we can do a letter for. Again,
as we touched, we can't do letters for federal agencies, IRS, Social Security. The communication constitute litigation document. Again, we cannot prepare legal documents for any of the members. And if the letter or the telephone call involves a telephonic hearing, which a lot of those are more and more common these days.
Yes, we have received calls where the members say, I have a telephonic hearing tomorrow. I'd like you to be on the call with me. Unfortunately, that's not covered under the consultation benefits.
Document review. After a consultation, the covered person may submit for review the following: any personal legal document. The document must be 15 pages or less and relates to the consultation. The covered person must be a contracting party. Linda, do you want to touch base on the doc review?
Mm-hmm. Yes, a lot of times the members, we do oftentimes have members who will self-submit documents before speaking to the attorney. A lot of times they're well over 15 pages. So we do give a little bit of grace, up to 20 pages. Not all provider firms do that. So if it's an out-of-state matter, I cannot promise you that they will review anything over 15 pages for free. We do have up to 30 pages, some flat fees that we will do for review. But once it hits 30 pages, it does require the matter to be done at the 25% discount. Something that we also will not do is review partial documents. So a lot of times if it's a contract and it's 50 pages, we're not going to just review the first 15 pages because that risks not only malpractice on our part because we haven't read the full document, but the member is not going to be fully advised of all their rights and obligations under that contract. When it comes to matters where the member is not the contracting party. Sometimes members will want us to review a sister's lease, or a brother's issue with a landscaper. Unfortunately, if the member is not going to be the one signing the document, or a dependent under the plan signing the document, we're not going to be able to review those documents. It would be a great time for that relative or friend to get their own membership because, if they had their own membership, and I've told members this before, we'll be happy to review it. Once they're members, we can certainly review those documents.
Yeah, they this when it says your personal legal document, it has to be your personal legal matter or somebody in your household. Mm-hmm. But it would be better written non-business, right? A non-business related legal document would probably be a better way to say it. And we do give some grace. Sometimes they send us a bunch of documents and you can sort of narrow in to what you really need to look at. If there's a closing, real estate closing, and they send you 8 different documents related to the closing, and that there's only one, we'll do that if we're able to do it. But Belinda's right. We wouldn't look at if somebody sends us 40-page document and we say it's over the limit, well, how about just look at page 6, 12, 14, and 19? That is really asking for trouble because there may be other aspects of the document that speak to the issues at hand, and the member just doesn't realize that. And we really need to take a look at it. A lot of large legal documents have definitional sections that define the terms in the document, and it's important to read those so that you know what these terms mean when you're reading them. So we really do need to see the complete document, especially in contracts. And so we will decline to do that. And folks may not understand that very well. It's not like we're looking to, charge everybody to look at documents. We really aren't, but we need to see the whole thing.
And I will say our document clerk is excellent. Sometimes members will send in what looks like 50 pages of material, but it's actually, the same 10-page contract 5 times because the member wasn't sure they got the document in, so they keep trying to email it because maybe they were in a spinning situation on their computer. So, she does take a look at them. She goes through them and she will let the attorney know it was 50 pages, but it just looks like a 10-page document. And then the file will move on.
Mm-hmm. Exceptions to the document review service. Documents reviewed service do not include. Go ahead, Belinda.
Review of a document for use in ongoing court proceedings or lawsuits, such as petitions, complaints, or requests for motions for court determination. I will clarify here that we do need those documents if we're going to be referring you, so we know what's going on. However, we won't basically, again, assist in pro se representation. So if it's a situation where someone's being sued, we will have them send it in. We will take a look at it and let them know what's going on, and that they need a referral. I will say any sort of litigation document that involves litigation in another state, another provider firm will not take it to look at or give a consult on. They will immediately recommend a discount referral. Again, documents involving business matters. Mike just touched on this. If it's a lease and they're the landlord, we're not going to look at it unless they have the home-based supplement or a business plan. Some people are trying to start a business or involve themselves in a business. In those situations, again, we'll give the courtesy consult, but encourage them to get the business benefits, either under the addendum or through their own small business plan, but we will not review any business related documents under the family plan. Documents where the covered person is seeking negotiation or editing services. Any services for negotiating or editing are available under the 25% discount. So if basically someone's looking for us to rewrite a contract, we're not going to be able to do that under the document review services. We can give tips and pointers. If it's a small situation where, there might be some words that aren't so clear, we'll recommend to the member that they go back and get that changed. But if it's redlining the whole document, recommending changes, doing extensive editing, we are not going to do that. We are also not going to go back and forth multiple times with the other side trying to get those changes accomplished. And as I was saying, documents in excess of 15 pages can be reviewed for a flat fee up to 30 pages, and then at 30 pages, the discount.
And I see a lot of times when the attorneys and the members are aware of this, they actually do not have a problem paying the few extra bucks to have the entire document reviewed. We can take the credit card payment from the member, process the payment immediately, and have no time wasted for the attorney to get to review the documents.
And just to add one more thing to that, I find that many times when I explain to the member why exactly I need to review the whole document and can't just review 15 or 20 pages, they many times will actually pay for the review. Sometimes they won't, they'll just say, oh no, never mind. But many times they actually will, and they'll pay. And then I give them the explanation when I go through the entire contract again, as to why it was important that I reviewed the whole thing, not just the first 15 pages or whatever they wanted to send in.
Out-of-state consultation services. Out-of-state consultation services are available to a covered person under the legal plan. Note, the membership contract only provides for legal services in the 50 states of the United States. Go ahead, Belinda.
Yes, and they have to go through us first, before we send it out. We do get a lot of requests for Canada. We still are not able to refer to there. I've done a couple favors for Canada, but it's not something that is under the membership. Puerto Rico, we don't refer there. Anything overseas, Mexico, there's just, and it's explicit in the plan. It's just the 50 states. And when it is inside the United States, we will make a request to the other provider firm. So if it's an issue in Maryland, we will make the request, and we explain to the member that we are making that request, and we will furnish whatever documentation the member has provided, fill out a form for them, and then they let us know if they're willing to accept it, and then they'll take it and they'll provide the member with the same services that we provide here at our office. And if the matter does need to be referred, they will notify us of that or send the member back to us to get that referral effectuated, and we will arrange for the discounted referral. And then Native American legal issues, there is no coverage. So we get a lot of those with the gambling type of calls at the reservations. Some of the payday loans out there are cite Native American law, that sort of thing. There is no coverage for anything that cites Native American law or the tribe of X, there's no coverage for that.
So now we're going to go through a couple of scenarios for everyone. I'll go ahead and I'll read the scenario, and then Belinda will let you know if it's covered or not covered. Albert takes a trip to Las Vegas with some friends. While in Las Vegas, he rents a car and causes an accident with another vehicle at a red light. He has now received a letter from the insurance company for the other driver about the damage he's caused to the driver's vehicle. Can Albert receive a consultation with his attorney in Nevada regarding his rights and obligations?
And the answer is yes. As I just explained, there are out-of-state benefits available to our members. So under the consultation services of his plan, Albert can receive a consultation on matters that occur out of state. So the attorney that he speaks with will offer him a consultation with an attorney from the Nevada LegalShield provider firm.
Cynthia calls in regarding an issue with one of her customers. She is having a difficult time collecting payments from that customer for a custom item she has made. The customer is claiming that the item is defective and therefore refusing to pay Cynthia. Can Cynthia receive assistance under her consultation services?
In this circumstance, the answer is no. This is a business matter. So under the consultation services, Cynthia has no coverage for business-related matters. She will be advised to upgrade to a business plan. In this case, depending on the nature of her business, if it's something out of her home, it would be a home-based supplement to satisfy her business-related needs. The attorney will still give her advice, but in this circumstance, she's probably going to want a letter. She's probably going to want a letter to that customer demanding payment. So in order for her to get that letter, she'll have to upgrade her plan.
Okay, Andrea's spouse of the membership calls in to her provider firm regarding a possible divorce from her husband, Marcus, who is the primary member on the membership. Is she able to receive a consultation?
And the answer is no. As Mike said, there's no coverage at all for the dependent. In this case, the dependent spouse. They're not available to the spouse under the legal membership regarding any matter that would place them in an adversarial position to the listed primary member spouse.
Jacob decides to take a vacation to France. While in France, someone steals his luggage out of his hotel room. Jacob calls in and requests a consultation on how to pursue the matter in France. Are consultation services available to him?
And the answer would be no. This, again, is not a matter that's arisen within the 50 states. So under the consultation services, Jacob can only receive assistance for incidents and legal matters that occur within the United States. International matters are not covered.
And there's an exclusion for things where we're jealous of the member, and this guy was in France. We reserve our right to be jealous and not answer his questions.
Yes. I had a member once who was injured in Australia, and it was a good case if it happened here in Pennsylvania. I was very, very upset that it happened in Australia.
Okay, Jessica calls in regarding her cousin Cleo, who has been cited and charged with public drunkenness in an incident exposure following a rather festive party at her home. Jessica would like to get some legal advice to assist Cleo in disputing these matters. Can Jessica receive coverage, such as advice and assistance?
The answer is no. Cleo needs to get her own membership. We would encourage her to do so. They don't provide coverage or consultation benefits for individuals who are not listed as a spouse or dependent. Since she is Jessica's cousin, Cleo needs to have her own membership, and any legal advice, that's okay. Any legal advice that we would give, we couldn't give Jessica legal advice for her sister. We are not supposed to give legal advice to a person whose legal issue it is not. So it's not Jessica's legal issue. We can't give her advice for someone else. We even encounter this when they are dependents. Like mom will call in about adult son's legal issue. And sometimes we have to explain to the mom, this is your son's legal issue. He's over the age of 18. We need to speak to your son.
Simon calls in regarding back wages owed to him by his employer, Smith's Seafood. Simon, however, received his legal plan through his employer, and there's an amendment to his plan. Can Simon receive assistance?
And the answer is no. Because he got his membership through his employer and his plan has an amendment, there are not any benefits available to Simon that he has against his employer. If he had his own separate legal family plan, that he did not get through his employer, we certainly could have assisted him here.
Brian has received a collection notice from Shady Credit Collections, threatening to file legal action against him for a debt allegedly owed to Green Mountain Credit Card. Brian has never had a credit card with Green Mountain Credit Card and is fearful that this company will not only file legal action against him, but also ruin his credit. He contacts his provider firm for assistance. Can Brian receive a telephone call or a letter in this instance to assist him?
And the answer is absolutely yes. In fact, this is a very common type of call that we receive. We are always getting calls on collection matters, especially collection agencies who may not even have the right to collect. So many times these collection agencies buy the debts from the original party without having the appropriate paperwork signed between them to effectuate the purchase of the debt. So that is also a challenge that can be made in litigation. But our attorneys, we have a few attorneys who are very skilled at collection types of calls and handling those types of collection matters for the members. And we've had quite a few success stories in this realm.
I was just going to say that our attorneys will let Deb and I know if they've had a success with a collection. And Mike, also, if you follow us on Facebook, post a lot of our success stories that y'all can share with your members. It's just a great way to tell our story and how we help members with just a letter or a telephone call. I know our attorneys like to see their praises on our social media, and members also like to see the success that we have. Dennis has been sued by his auto mechanic, Flynn's Fixer Uppers, for failing to pay for repairs that Dennis claims were never actually made by Flynn's. Dennis calls into his provider firm requesting that a letter be written to the court on his behalf, responding to Flynn's complaint and explaining why he feels he does not have to pay for the repairs. Can Dennis receive a requested letter?
In this situation, unfortunately, no, we cannot do letters to the court. So the letter he's requested is considered a responsive pleading that has to be filed. It's not a letter. And our attorneys will explain that to the member, that it's not a letter, it's a responsive pleading. It's a different entity in and of itself. So this is something that could only be filed by a representative counsel retained by him under the discount services, or he would have to respond on his own, make his own response pleading. You know, certainly in this situation, we have a lot of auto mechanic calls that we get, you know, with faulty repairs and things like that. You know, it's always good to encourage the members to call us before it reaches litigation, because sometimes our attorneys can do a letter when it's, you know, prior to litigation, when Dennis in this situation would have a really good defense, you know, that we could assert for them. And sometimes if the mechanic sees that he's contacted an attorney already pre-litigation, they may be more hesitant to file that legal action.
Mary recently had surgery at a local hospital. The hospital submitted her bills to her medical insurance carrier, who denied coverage. Mary contacted her insurance company by telephone and disputed the denial. However, the insurance sent her a second denial. She has been told that her only option at this point is to file a letter of appeal to the insurance company. Mary contacts her provider firm in order to have inquiry whether a letter can be done on her behalf. Can the consultation attorney write this requested letter?
And the answer here is no. This is one of those appeal circumstances with insurance companies that requires a representative to write the letter of appeal. We are not formally retained, so we don't meet the definition of representative in most health insurance appeal definitions. So since this is an administrative appeal, she would need to have the referral under the 25% discount. Now, most of these cases, she can write her own letter, and I have encouraged members to write their own letters of appeal, and I would be happy to take a look at it, you know, and let them know if it satisfies the elements. I can't aver to the facts or things of that nature, but certainly, you know, there's limited assistance we can give. We just can't do the letter.
Drew was recently involved in a car accident with Corey. Since the accident was Corey's fault, Drew filed a claim for the damage to his car with Corey's auto insurance company, Devon Property and Casualty. Devon Property and Casualty has denied Drew's claim, and Drew has now called his provider firm seeking assistance. Can Drew receive a letter or a phone call in this matter?
The answer is absolutely. These are the types of insurance letters that we can do. We do a lot of letters for property damage in motor vehicle accident cases. You know, we can do letters to the other party. We can do letters to the insurance companies. You know, we can do letters to the repair shops. You know, I've done all of those things personally. You know, I'm sure Addie's done a few. You know, this is definitely an area where the correspondence, the letter benefit is well utilized and a true advantage for the member.
Sorry. Colleen has filed a lawsuit at her local magisterial district court. She needs a continuance of the hearing and calls asking for a letter to the court. Can she get a letter?
And the answer is no. She's in litigation. Most courts, when you call them, they will say, oh, are you representing Colleen? No. Well, have Colleen call and ask for her continuance then, you know. So, you know, we will certainly give advice on how Colleen can request that. And obviously, once she gets that, we can offer her the discount. But a lot of members have a hard time understanding why we can't make that call. It's simply because most small claims courts require, if an attorney is going to request a continuance, it's got to be the attorney who's going to ultimately represent the member.
Molly calls her provider firm because she paid a contractor $10,000 to remodel her kitchen, and he has disappeared. The consultation attorney sends a demand letter to the contractor with a 30-day response deadline. Molly calls back on the 30th day and demands a second letter to the contractor. Is she entitled to a second letter at full charge?
And the answer is no here. However, I will say I can't think of a single attorney in my office who won't do a courtesy follow-up letter in this situation, giving them one more opportunity to respond. But technically, under the plan language, the answer is no.
Okay, Belinda, I cannot say this name.
Rhiannon.
He went in there. Yeah, we'll use Mike. Mike is taking a vacation this summer to Myrtle Beach, South Carolina, and plans on renting out a beach house. Mike would like to have the 10-day the 10-page rental agreement, which is governed by law of South Carolina, reviewed. Can Mike receive assistance with such a review under his plan?
The answer is yes, absolutely. We would encourage the member to send in the document, and we would then arrange for a benefit one or consultation consult with the South Carolina provider firm. We would fill out the form request for them, attach the documents, and then the member would receive a call from a South Carolina attorney who would be happy to review those documents.
Sean is interested in purchasing a franchise with a national company, Irish Baked Goods. He has a 75-page franchise agreement that he would like reviewed by his provider firm. The contract is controlled by Pennsylvania law. Can Sean have this document reviewed at no charge under his plan?
And the answer is no. And I will say that a franchise agreement of 75 pages is on the smaller side. There's two reasons why this could not be reviewed. The first is obviously the fact that it's a business matter, not a personal matter. Purchasing a franchise is purchasing a business. So that would not be covered for that purpose. It's also way over the 15-page limit and also over the 30-page limit. Plus, Mike would agree with me here that franchise agreements have a lot of things involved with them. So it's not a simple document review. It's generally a complex document review. Would you agree, Addie? You know, these are not something that's just the attorney's just gonna be able to take a cursory glance or you know, even a regular review if it's inside the 20 pages and be able to feel that they've competently assisted the member, given all the issues involved with a franchise type of agreement. So there's multiple issues with why this would not be covered under the consultation benefit.
Yep, I absolutely agree with you, Belinda. Even the shorter franchise agreements are extremely complex, but most of them are well over 100 pages.
Dr. Jones calls because he has been offered a job at a small town memorial hospital and would like a review of the employment contract, which is 15 pages long. Is the document review covered under the document review service?
And the answer is yes. There it is. His plan allows for him to have an employment contract reviewed, and since it's 15 pages, he can certainly receive that under his document review services.
Patricia and her sister are having trouble getting their security deposit back from a recent rental. Patricia would like her provider firm to review the lease and send a demand letter if there is money owed. Can this be done under her membership?
And the answer here is yes. Even though her sister is not a member of LegalShield and not on the membership, since Patricia is a party to the lease agreement, there will be services available for a document review and a letter under her plan.
Greg is seeking to purchase a boat from his next door neighbor. He contacts his provider firm in order to draft up a sales agreement and negotiate payment terms. Will this be covered under the document review service?
And the answer here would be no. While the attorney would be willing to provide advice and review an existing sales agreement, any drafting of a sales agreement or negotiating with the next door neighbor is something that would be covered under the discount services.
All right, that concludes our PowerPoint. Do we have any questions?
On the guy driving the boat, we would also tell him, don't do it.
Yeah.
Right? Anybody that's owned a boat realizes, you know, that old adage, right? The best days of boat owner is the first day and the last day.
Yeah. Rent.
Exactly.
So I have a question.
Sure.
Okay. So did I hear somebody say that members cannot use the membership against us as associates?
Yes.
Only you, Harvey.
I know.
If they,
and I know,
you know,
I know you
yeah.
do it personally, Mike.
Yeah, we screen those out on the front end. I won't say that they don't slip through sometimes, but if they do slip through, the attorneys catch it because they'll be saying, Harvey sold me this plan and he took my money and blah, blah, and I have this big complaint about him. We'd be like, whoa, wait. We unfortunately, Mr. Smith, we can't assist you with this, under your plan. This involves an issue with a LegalShield associate, and that's excluded.
I knew that was part of the employee benefit part, that amendment that was added, but I didn't know it was standing.
Yeah.
And when I talk to or enroll new members, I try to get it into their head the 4 secret words to get the best service. And I tell them when the call taker asks, okay, so how can we help you? When the attorney calls back and says, how can we help you? The 4 secret words are, I need advice on, because that's the main benefit, in my opinion, of the service. And don't call in and say, hey, I need a letter done. I need a contract review. Just say, I need advice on a contract that I have that I want to sign. I tell them, even if you need to get a will done, just call in and say, I need advice on getting my will done. So I would encourage any associate that is listening, those are the 4 secret words. And I won't say I've never had any members complain, but it's very few members that have complained about what you guys have done then for them. Thank you very much for everything that you guys do.
Oh, you're welcome.
Thank you.
And by the way, I've had you guys do extra things for me. Years ago, I had a situation with the Philadelphia Parking Authority. Yes, you guys did write a second letter, no charge, because they refused the first letter, said, hey, you still owe the money. I did have a consultation with the law firm in California because of the GoFundMe terms and conditions are based out of California. So this membership works. It's awesome having a law firm in every state in the country.
Definitely.
I got a couple questions, Mike.
Sure.
First off, I wasn't aware, I'm probably thinking a lot of associates didn't know that people cannot use the membership against a LegalShield associate. I find that's good to know. I don't know if that's stipulated somewhere in a contract that we have, but I'll certainly inquire about that. So in a case, and this happens quite a bit, as associates, we work with other associates in commission splitting or sharing costs for different types of things. So and it's never happened to me, but I've heard stories if something was to go wrong and those associates were in a disagreement, what would be the process? Could they use their provider law firm? Like I've seen associates go to the provider law firm, say, look, we want to do an arrangement and can you give us advice on how to maybe stipulate a little agreement or something? But let's just say they came to a disagreement. Where would that leave them as members?
Yeah, I can't say that we've ever had that. I'm not aware of ever having that type of a situation. Certainly if they were both in our state, that would at the very least be a conflict, right? We would have to at least send one of them out.
And possibly business related as well. If they
Right.
didn't
That's a
have,
good point. Yeah.
Or both
But
of
let's
them
say they
out.
had if they had the home business business plan, then.
Yeah, it would be a conflict at a minimum, and it might be a first to the plate. We would probably make a determination, and when we can't really determine what we want to do, we will send a request to LegalShield and get their input on it as well, and whether or not, and we'll tell them what our position is, and they'll tell us whether or not they agree with our position. And that's probably how we would add since that's a novel issue that hasn't come to us before. I know it would definitely go through Mike. It would probably be brought to Meyer and Noemi's attention, and then go through Mike, and then possibly LegalShield if we felt we needed to get their input.
Right. Fortunately, hasn't come up in 25 years. So.
Knock on wood.
A lot of the time, LegalShield corporate will manage situations too.
Right.
You can go to them about stuff.
So just generally speaking in the public then, I mean, we're nowhere near, a couple percent of the marketplace, right? So the chances of 2 members coming from, I'm sure it happens, right? And it's, first one in, but and this may just seem like a silly question, but I mean, are we ever getting to the point where, with so many different LegalShield members that every time somebody has an argument or disagreement, I'm going to call a law firm and just get an intake in case it goes south and I'll be the first one in. I'm just wondering if is there a certain point where we're going to say there's an intake versus I just want to make a preemptive intake? You know what I mean?
Well, if they make an intake, they're going to have a full consult with one of our lawyers. They
Okay.
will, our attorneys will call them back and they will give them a full consult because they're required to do that. And they're required to have detailed notes and say exactly what the issues involve. So if someone's
Right.
trying to just make an intake, and have it sit there, that's not something that we allow in our
So
process.
potentially, let's say any disagreement with a person or a neighbor, anything about something that, well, I mean, it can't just be we don't get along, but if it was property, if it was, I don't know, something involving money, I mean, it would be a legal issue and you could contact the law firm. Then if it progressed, then the first person who called in with that intake would be served first, right?
But
so.
the key here is that both parties are going to get serviced.
Well,
It's
absolutely.
just,
Yeah.
one's going to be serviced by us. The other's going to be serviced by a well-qualified attorney that we utilize as a consult, as a conflict attorney, who has meets the same standards as LegalShield requires of us. So they're going to get same quality of legal assistance as they would as if they had used us. So.
The spouse thing is interesting. I don't know that a lot of people would know that you have the primary member and everyone just assume that the spouse has equal rights and access. So I found that's a very good point that I don't think a lot of people, we never heard that talked about in any of our internal training. So I'm going to pass some of the stuff on to like Melissa Wilder and different folks to say, there's some things maybe we should clarify that people know. But one other area that I think could cause some confusion is, with the trial defense. Because these documents you're talking about, if there's a litigation coming in or a suit, most people say, well, that would be covered under my membership on the trial defense. But that
stay tuned because we're going to be doing a training on that as well.
Yeah, this is just the consultation and document review.
So,
we're deep diving into just this one aspect of the plan.
The other thing that came up, what if you had a situation where, let's say a 18-year-old, 20-year-old, 23-year-old living at home had their parent on their power of attorney? In that case, could they have a power of attorney but allow their parent to call the law firm on behalf, or is that just not legal? Like for a legal
we
issue?
we will take power of attorneys and especially like if the kid's away at college or overseas in the military, we will take all of that into consideration.
Okay.
So it is power of attorneys are used. We do require to see them first though. And if it's, and sometimes the attorneys will go so far if they feel it's kind of fishy, have the 18-year-old son at least speak to him once saying, it's okay to talk to my mom about this, so.
We're oriented to provide benefits without friction. So we like to reduce friction as often as possible. So unless there's something that, your antennas go up, right?
Mm-hmm.
Yeah.
That's where we'll be asking for something.
The only other question I have is just generally speaking, like when you consider most of the personalists that call in, like how often do you guys go over the 15 pages? I'm just curious if most policies, generally speaking, house insurance or something with your cell phone, these things are generally
every day.
A lot.
Every day. A lot.
But most of the time. Yeah.
Yeah.
If
that
it
power.
Well,
I was going to say, go ahead. Answer that
if
question.
If it's an insurance policy review, we will go over that limit.
Are the contracts like in general under 15 or over? That's kind of what I'm wondering. Like percentage wise,
depends on the contract.
Okay.
Yeah.
I'd say most of the ones I get are business related, and they are generally over 15. A lot of them are in between the 15 and 20, but they're almost always over 15.
Yeah. On that power of attorney, that raises a good issue on consults. We didn't really talk about powers of attorney where we often see this where, mom or dad have the plan and son or daughter has the power of attorney for mom and dad, and they're the ones calling in to access the benefits, talk about something for mom or dad. Those are real sort of tricky issues. Sometimes they're, perfectly appropriate. But sometimes whenever daughter's calling in with a power of attorney on behalf of dad and refuses to put dad on the phone time and time and time again, right? Yeah. And we've talked to dad in the past, and we know dad's okay, or at least was okay the last time we talked to him 6 months ago. That's a little fishy, especially when daughter's saying, dad's decided to give me his house, please prepare a deed. Right? Yeah. Those are sort of the judgment calls where you're probably going to get a little bit of friction there, or we're going to say, we're going to call dad back whenever daughter's maybe
Yeah.
not around.
Mhm.
You know, those are the tricky situations.
Yeah. Well, anyway, I really appreciate this. I mean, this has been, I didn't expect all this. I think those situations are great. I mean, I'm in Canada, but I mean, it just gives you a good sense of some of the, you know, the types of situations. And I mean, they're always going to be case specific, but you guys did a fantastic job. This has been really informative. I'm a little
Thank you.
disappointed there's
Thanks.
not more associates
Thank you.
on this.
Are you in BC or Ontario? or-
Winnipeg.
Winnipeg. Okay.
yeah.
Winnipeg. Wonderful. Glad to have you. Yeah, we're always surprised. We sometimes don't get associates to attend. We do these at different times of the day. We love doing them, but we're going to post it on our YouTube channel, so it'll be out there for everybody to see at their leisure.
Oh, that's great, because that was my question in the comment
Yep.
box if there's a replay. So awesome.
Yep, there will be a replay.
Yep.
One of the ways I recently had a contract reviewed, my son runs cross country for a local school district, and they wanted me to sign a COVID release form. And my husband, who does contracts for a living, looked it over and thought that it just looked kind of extreme for, you know, running in a school sport. And I was able to send the contract in and have it reviewed. And the attorney that I talked to said, you know, if you don't sign this, chances are your son won't be able to play. But they were able to, I said, well, are there any modifications that I can make to this contract? And she said, it was just a 1 page. And she's like, well, yeah, you know, this seems off. She's like, cross this out, cross that out. I actually use it as an example when I talk to people, and I crossed out a whole bunch of stuff on the paperwork. And then I wrote at the bottom that it's only valid for this school year, for like the 2021 school year. And I signed it and submitted it. They told me that if the school district balked at it at all, to let them know. And I submitted it, and nobody ever gave me any issues. And we go to a school district where there's 1,000+ kids per grade, and you know, how many of them play sports? And so that's one of the stories that I've been sharing during this time, because I just don't think that people realize like how they can really use that. And my son received a bill for his fraternity that he was in. He said they told him he owed fraternity dues. And I think he got on the phone and talked to the attorney, but then the attorney was more than willing to talk to me, and we got everything worked out. And so it worked out really well. So thank you guys for all you do.
That's a great example, Kim, of how to use a great situation to use a membership. They tell you it's a COVID release, but if you actually read it, it probably releases them from a lot more than COVID related issues.
It was like for influenza, it was for any communicable disease, known or unknown, for every single person that goes to any event, like ever. It was crazy. I couldn't believe it.
Exactly.
And that's something I would encourage you to tell your members, because one of the frequent things that I constantly will review and recommend, like you said, putting lines through and initialing and Xing out, are releases of medical information to insurance companies with auto accidents, medical cases. Those releases are so general and so broad, and you are releasing almost your entire medical history to them. And all they're entitled to is your medical records from that accident, and then anything that may have relevance to those injuries. That's it.
Right.
So there are often times where I will tell a member, whoa, before you sign this authorization, let me look at it first, because I'm probably going to recommend you make some changes. So if you have any members who have any sort of authorization, or they're involved in an accident or anything like that, please, before they sign any paperwork, have them call us.
When you're marking up those waivers, it always helps if you're putting them in a stack of other waivers to pick it up and put it like in between, so they don't see that you've marked it up. They just collect them all and put them in the file.
Yep.
Well, I think the school district next year, I think they're making it electronic. So I don't think I'm going to have a choice but to have to just like elect it, or maybe I can print it out and submit it separately. I don't know what my workaround will be next year, but I think I'll run it. I think they've kind of integrated into technology for next year. So we'll see how it works. But
yeah, I didn't like that either. I had to do that for Duquesne, my daughter, and I complained about something. I can't even remember what it was. And they told me I could do it differently, but you don't have to just, I tell people, LegalShield people don't have to take no for an answer anymore, right? That's, you have that freedom. We don't have to take no for an answer.
Maybe one more quick question. I had somebody this happened to where, everybody travels and they go across the world to other countries, but they might be staying at a Holiday Inn or some, big chain, and there's something going on there. So technically they wouldn't be covered, but I'm sure there's probably circumstances where a law firm give probably pretty good general advice on how, in terms of you know, how to deal with that hotel or something, or a rental car or whatever. Would that be fair? Or
Well, it depends on what the legal issue is, because, you know, you would be surprised at the different laws just from state to state on contracts, you know, on collection, you know, that even with statute of limitations or what's considered, you know, in some cases, in some states, you can attach wages for certain circumstances, in other states you can't, you know, so it, you know, there might be situations where it's a general thing and we could write to Holiday Inn corporate in the US, you know, or just at least give some advice about it. But at the same time, you know, we would have to qualify saying, hey, look, you know, this happened in Puerto Rico. So this may not involve, this involves Puerto Rican law.
This would be more like
so.
people that are down there and they've got a problem, they're not getting service or something's, and, you know, and they want to get it resolved. So I'm just wondering if, like, the law firm calling the manager of that hotel or that rental car place to try to get them out of the emergency, if you want to call it, you know, it's not really a 24/7 emergency, but they're in a situation where, like, okay, they're going to lose a lot of money or not have something go drastically wrong in their personal life but they just happen to be outside of the United States and they're in Hawaii, or not Hawaii, but they're in Cancun or they're in some place, right? So, but I mean, technically they're not in the US, and, you know, we can only cover so much. But I thought I did hear some stories sometimes about some law firms giving them something over the phone when they were in a crisis, you know, in Barbados or some place, right? And so I don't know.
Yeah, dude, they won't upgrade me. My wife is going to kill me if I don't get this. Can you help me out, man?
But I mean, in all, in doubt, would you not just say still call the law firm? What can it hurt, right? I don't know.
Yeah, that on those EA, the emergency access calls, you have to call Oklahoma first, and they decide whether it's an emergency before it gets put through. And my guess is that probably wouldn't get put through.
Right.
You know, maybe if you were there and you had a reservation and they wouldn't let you check into the room and you had no other options, they would do that. I don't know. Those are pretty unique situations. So.
Okay. Thanks, guys.
So,
gals.
Okay. All right, everybody. Well, I think we're probably over time, so we really appreciate you attending. I'll ask if you see these come up again, please share it with your friends, encourage them to attend. We always appreciate Google reviews. If you wouldn't mind going on our Google listing and giving us a Google review, we would really appreciate that too. And we hope to see you sometime soon. So thank you. Have a good night, everybody.
Thank
Thanks
you.
so much.
Good
Stay
night.
healthy and
Thank you.
safe.
Bye-bye.
That was great. Thanks, all of you.
You're welcome.
You're welcome.